I remember the exact moment I realized someone thought they could hijack my life. A crew started unloading mowers in my driveway like they owned the place, and a piece of paper later told me I owed $2,500. Bangay Dungda, they sent people to fix my lawn without asking, and then expected me to sign up to their club like it was a freebie. I moved into Aunt Martha's house thinking I was stepping into quiet, into a lifetime of books and sunlight, but instead I walked into a slow, polite kind of warfare. I grew up thinking property was simple. You own it, you decide what happens on it, end of story. Aunt Martha had the kind of stubborn that reads as history librarian for 40 years, never married, bought a Victorian in 1962, and lived there 40-some years tending roses and reading aloud to no one in particular. When she died, she left me the house clear as a bell or so, I thought, and I drove out 30 minutes from the city with boxes and a hopeful grin. The house sat on an acre, a wraparound porch that creaked like an old friend bay windows that stole the sunrise, in a garden that had turned into a jungle because life kept happening. I loved it already, and I hadn't even unpacked the coffee mugs. A week in, while I was still finding places for Aunt Martha's old tea tins, a thick manila envelope arrived, no return address, and inside an official compliance package, an invoice for $2,500 and a list of 14 violations. My front door was the wrong color, the grass was too high at 3 inches, and Aunt Martha's roses were apparently illegal. I sat there at the kitchen table, the morning sun through the bay windows, reading the words and feeling the room tilt. I never signed anything. I never agreed to join any homeowners group. As far as I knew, this property was mine, no strings. A man in a dark suit showed up 2 days later. Shiny watch, practice, smile, legal counsel for Golden Oaks Homeowners Association. And before I could finish hello, he was already stepping inside my doorway, talking as if my consent were a box to tick. There was a joiner agreement on his clipboard, signature lines highlighted like bait. He claimed the covenants ran with the land, that my aunt's property had been incorporated into the development. When Golden Oaks went up a master plan, the city approval covenants filed with the county. His voice was oily with certainty, and when I asked for the recorded documents, he danced around specifics and dropped an artificial deadline sign by Friday or face enforcement. Everything in me bristled. He left a business card, heavy stock impressed, lettering the kind of flourish meant to cow people into respect. I made notes, the non-answers, the vague legal phrases, the deadline, the way his smile said, "This is standard," but his eyes scanned me like I was an inconvenience. I called my cousin, who works as a paralegal. She agreed joiner agreements are usually used to add properties that weren't originally part of a development. Why would they need my signature if the covenants already existed? The logic smelled wrong, so I tested them. I did nothing. I left the door yellow. I let the grass sit at 3 inches. I hung a little wind chime on the porch just to be cheeky. 2 days later, a landscaping crew pulled into my driveway like a SWAT team for shrubs. They had a work order, they said. The HOA told them to fix my yard. I stood on the porch and told them to leave. "This is private property, do not touch anything." And the supervisor shrugged and went back to the truck like I was the odd one out. I called Sterling Legal Services. Yes, that was his firm, and the voice on the other end tried the old gentle threat: fines, liens, court. Pay up sign, be reasonable. I drove to the county recorder's office the next morning, a building that looked like it was tired of being there, and I dug through records. Deeds, transfers, notes. Nothing that looked like HOA covenants tied to my parcel. Then buried in an old folder, I found a letter from 1988 from the City Planning Department addressing Golden Oaks Development Corporation. Petition for mandatory HOA inclusion. Parcel number listed my parcel number, and the key line the petition lacked: the required consent of the property owner. Objection filed, request denied. Aunt Martha had fought this battle 25 years earlier and won. My hands were shaking in the public terminal light. The plat map made it clearer. My property sat like a deliberate hole in the middle of Golden Oaks, excluded from the subdivision boundaries. I left the recorder's office with a folder that felt like ammunition. I didn't want a war, I wanted my home back, but I also wasn't going to be bullied into paying fees or signing away rights that didn't exist. Friday came and went. Monday brought a certified threat letter. They were preparing to sue. They cited statutes, they listed fines, they made every intimidating noise a legal team knows will make ordinary people cave. Instead, I wrote a letter back, polite, firm, asking for recorded document numbers and citation references. 2 weeks to respond. I sent copies to Sterling and to the board president, Brenda, and that's when the tone shifted from polished to petulant. Brenda called, shouting like the volunteer enforcer of suburbia. "Who are you to threaten the board?" I calmly asked for proof. She shouted that the community had existed long before I moved in, that I should follow the rules, and that legal action would be their tool. Their certainty felt like entitlement wrapped in clipboards. I hired a property attorney, sharp, practical, the kind of woman who reads a deed and sees where the lies sit. She smiled when I showed her the 1988 letter. "This is gold," she said. "We file a quiet title action, we send a cease and desist. We give them one more chance in person, and if they persist, we make them answer in court. They either back down or they pay for their own hubris." I wanted this resolved without piling up bills, but I wasn't willing to be gaslit. We invited them to a resolution meeting at my house, neutral language recorded for honesty. Sterling came with his briefcase and a poster tube, Brenda with her HOA pride and bumper stickers. Sterling unrolled a map and called my property part of Golden Oaks. My attorney asked to see the recorded document that created that obligation, not plat maps, not administrative details, but a recorded instrument linking my parcel to the covenants. Sterling produced the Golden Oaks CC and RS, a thick packet of official-seeming pages, but the legal description only bound the lots, specifically platted within the development. It did not, by text, pull in properties excluded by the recorded plat. Geographic proximity is not the same as legal inclusion. I played my ace. I slid the 1988 rejection across the table. Sterling read it and looked like someone had set down a hot coal. Brenda scoffed. "That's old." My attorney's voice was calm and cruel. "Has there been any subsequent recorded agreement or court order that overrides this? If not, that letter stands." The room tightened. I told them what I thought had really happened. Golden Oaks wanted my parcel for aesthetic consistency or expansion. They tried to bully an elderly owner for years, and when Aunt Martha resisted, they stopped. When I inherited the place, they smelled an opportunity, pressure tactics, fake deadlines, crews dropping in to make the problem look urgent. When I said fraud, the word landed like a hammer. Sterling's color drained. My attorney handed him a cease and desist and explained the quiet title action we were ready to file. She listed damages, my lost time, legal fees, stress, and mentioned professional conduct questions about making legal claims without basis. Sterling flailed. Brenda ranted. The meeting ended with them packing up, muttering about reassessing, and me watching them leave with the surreal relief of someone who just survived being told they were wrong and proved it. 3 days later, Sterling sent a letter that read like a retreat. Ambiguities discovered. Golden Oaks would no longer claim authority, and as if to apologize with cash, a check for $5,000 as compensation for inconvenience. My attorney confirmed it closed the matter effectively. I could have pressed for more in court. Maybe I could have gotten a bigger payday. But my real victory was bigger and quieter. My rights were recognized, the harassment stopped, and my house stayed a little island of defiance. So what did I do with the settlement? I painted the front door electric lavender, a color specifically prohibited by Golden Oaks covenants, and I installed a 20-foot flagpole in the front yard, American by day, and a cheerful rainbow by evening. The rules about flagpoles didn't apply to me anymore, so I made a small, deliberate show of it. The best part was, the day I saw Brenda walk by, stare at the bold door, and the pole, then look right at me on my porch and shake her head in disgust. I raised my glass of iced tea and smiled. Some battles are worth fighting, especially when the law is on your side, and the opposition mistakes bullying for authority. That should have been the end, but life, of course, kept handing out small dramas. A few months later, I was hosting tabletop game nights. Yes, this is a pivot, but stay with me. And we had a player named Joe and his girlfriend Carrie, who turned out to be the emotional equivalent of a landscaping crew, showing up late, causing damage, and leaving other people to clean up. Carrie had this thing where empathy was optional and attention-seeking was mandatory. She would derail the game, make jokes about trauma that landed like nails, and treat apologized boundaries like suggested guidelines. I tried to be kind, I tried to be patient, but kindness has limits. On my birthday week, they promised to come, then canceled because of concert tickets they'd forgotten. Carrie blasted me a long text about how I was being unreasonable for needing space, when honestly I had been hurt by repeated flakiness. She copied and pasted drafts from a chatbot to write her messages, then defended it by saying she was removing emotion from the conversation. It was performative cruelty. She announced from the rooftops that she was showing grace by stepping aside, but demanded that Joe make a public declaration that we were wrong, and she was right. It was gaslighting wearing a party hat. The friendship with Joe, who had conceded too much, quietly ended. That was less dramatic than the lawn war, but it left a different bruise, the kind that tells you the people you trusted have limits to their loyalty. So what's the takeaway from these two small wars? First, authority is not the same as legitimacy. A clipboard and an aggressive tone can't invent legal rights. Second, the law is a tool you can use to protect yourself, but you should choose your battles. Sometimes a settlement and a lavender door are worth more than a courtroom trophy. Third, people will test boundaries in neighborhoods and friendships, and sometimes standing up calmly and with proof is the simplest form of self-respect. Now, I want to ask you, when someone in power leans on you with threats and a smile, do you back down or do you dig for the record that proves them wrong? Tell me when you've stood up and what happened, or tell me if you think I should have pushed harder. Was I too soft, too loud, or just right? Share your story and tell me what justice looks like to you.